using that tool?
Yeah, with that tool, she responded that she perceives her social support system, especially with respect to her family relationships, as being tenuous.
And in your report, you indicate that she actually holds negative feelings about her family and blames them for difficulties. Is that accurate?
That is what the instrument indicated. It's also consistent with her presentation over the course of time.
And how can that impact someone's risk for violent recidivism? If that's the feelings that they hold regarding the two closest family members to them?
In and of itself, fractured family relationships wouldn't necessarily augment a person's risk if there's additional levels of support that they can rely upon. In Ms. Geyser's case, she would have the benefit of rather significant professional support surrounding her if she were to be discharged to the community. Ideally, she will continue to bridge those gaps that exist with her family members and continue to strengthen those. However, frankly, a lot of people in the community don't have great relationships with their family, and in and of itself, like I said, that doesn't necessarily suggest that she would be a higher risk for violence. It's just one factor to consider, especially when we're creating a risk management plan for her discharge to the community.
Sure. Thank you, Doctor. I have a couple of questions about one of the other risk management factors, the non-compliance with remediation factor. What does that mean? Can you tell the court what that factor is talking about?
So that factor would be trying to predict her, when it comes to the risk management factor, trying to predict the likelihood that she is to follow the conditions and expectations of her treatment plan, of her supervision plan. In her particular case, she does have a history of essentially pushing back on expectations. However, that is been now years since she did that. Her recent stability and rule compliance in the institution does bode well for her success within the community, especially given her more recent willingness to accept feedback and guidance from individuals who are involved in her care.
I want to ask a couple questions, Doctor, about there seems to have been a couple recent changes in diagnostic findings regarding Ms. Geyser since we were last in court for the last conditional release hearing. Your report indicates that there was a psychological assessment in May of 2024 with Dr. Myszak, M-Y-S-Z-A-K. Is that true?
Correct.
And did that psychological assessment result in a new diagnosis?
That particular evaluator opined that there was support for a diagnosis of autism spectrum disorder.
And is it true that that doctor suggested individual therapy with a goal that Ms. Geyser advance her understanding of that condition and its impact on her?
Yes.
Is it also true that there was another psychological assessment in September of last year with Dr. Hessler, H-E-S-S-L-E-R?
Correct.
And what was that assessment in regards to?
So on May 31st of 2024, the 10-year anniversary of the index offense, Ms. Geyser indicated to her treatment staff that she identifies as a transgender male, and to be clear, I'm using female pronouns and her court-given name just to be consistent with the collateral records. But since that time, she has identified as a transgender male and has made efforts or begun having changes to essentially live as male. So in the treatment records, she's now identified with male pronouns and a separate name. Also, the use of recently the use of a breast binder.
And that was the impetus for the assessment with Dr. Hessler?
As I understand it, the institution staff referred her for that assessment, essentially to determine if there was implications of her underlying mental illness playing a role in the decisions and identity changes. The examiner at that point opined that there was not evidence of psychosis or other significant mental illness impacting her gender identity, but rather this has been a process that has been ongoing for quite some time.
And part of that process, actually going back to November of 2023, Ms. Geyser identified as non-binary. Is that true?
Right. At that point, she identified as non-binary and had asked, I don't believe that she had specific pronouns that she wanted to use, but had begun to identify as a different name.
Now, is that name the same name that she identifies as now?
It's not.
Okay.
Since essentially coming out as transgender male, she has chosen a distinctly male name.
Okay. And ultimately, through that assessment, Dr. Hessler offered a diagnosis of gender dysphoria for Ms. Geyser. Is that true?
Sure.
And that was September of last year.
Correct.
Is it significant to you that there are these diagnostic changes since the last conditional release hearing?
It's notable. Neither of those diagnoses, however, necessarily impact her risk for violence. When considering the changes to those particular diagnostic changes, I think it's important to note that the impetus or the problems, the issues are not new. These are things that are documented in the record. It's essentially just a label that has been attached, and there may be disagreement across the professionals about whether or not those are appropriate diagnostic labels, but there is full agreement that the symptoms or the issues are in place and have been for quite some time.
Okay, so we're learning Morgan Geyser has a diagnosis of gender dysphoria since last year. She's identifying as a male now. Okay. Be that true as it may be, that's her identification at this point in time. The question, though, that's most relevant for this court is, should she get out? And where should she go? Hopefully to another prison. If she doesn't need the psychiatric treatment with this current incarceration, then hopefully she's going to be locked up somewhere else, because who cares how she identifies? We care if she's dangerous. Let me bring in our legal analyst guest, trial attorney Cannon Kearney, watching along remotely. Good morning to you, Cannon. What do you think about this young defendant looking to get out after she's been sentenced to 40 years on that plea of not guilty by reason of insanity, which, as you know, has the legal effect of, a conviction, and she's got to serve the time and not be a danger to anyone else as part of that conviction. Your thoughts, please.
Well, good morning, Julie. As always, happy to be here on Court TV. And just thinking about this, it's clear that this community truly wants the best interest for this defendant, this person who is now currently being in a mental psychiatric place. It's clear that they're devoting all of their resources, all of their staff, all of their attention to trying to get her out of this place. It's come to me that other communities with different individuals who may look different than the defendant may not have put in this type of resources or this type of time and attention. So I would say, based on that, it's clear that the judge should have a very, very well-rounded information about how to move forward. What I would say is they gave her the playbook last year when she came to court. So, of course, she's going to follow lead and say that she's no longer faking what occurred when she was convicted previously at 12 years old. So I would just say that after a year, I don't know that they have enough information to go off to say whether or not that she's ready to be back in society. So I would personally not believe that she should be released. But it's clear that the individuals who are here testifying on her behalf, or the psychiatric or health individuals who have worked with her, truly do believe that she's ready to be back in society.